Hi, this is Sean Bland. I'm an associate at the O'Neill Institute for National and Global Health Law, where I work mostly on HIV law and policy. And this is the third installment of our HIV Health Justice speaker series. And today's speaker is a research assistant with the O'Neill Institute and also a global health law LLM student at Georgetown Law Center, Safura Abdool Karim. And I will also be assisting her. This is research that the two of us did in relationship to criminal immunity for sex workers and people who use and inject drugs.
So as Sean mentioned, I'm an LLM at Georgetown University, and I'm also a research assistant at the O'Neill Institute. Before coming to Georgetown, I completed my law degree in Cape Town, South Africa, and then I worked for a while, and then I came here. And today's presentation is really informal. You can ask questions if you have any questions. I think there's a way to ask questions on the internet as well, so people should do that.
That's a good reminder, actually. So there is a live chat feature on YouTube, and we'll be monitoring that. And so if you have questions throughout the presentation or at the end, please feel free to ask the question that way, and we'll make sure that Sephora and myself get it, and that'll be part of the discussion. And you also can join the discussion on Twitter by tweeting at O'Neill Institute.
So today's presentation is really about a project that Sean and a piece of research that Sean and I did about criminal immunity for sex workers, and also how states have adopted Good Samaritan laws to deal with drug overdoses. So just to give you an overview of what the presentation will cover, when you talk about criminal immunity, either in the context of sex workers or in the context of intravenous drug users, you're really talking about harm reduction. So that's kind of the context that all of these laws arise out of. So we're going to start by discussing what harm reduction is. We're then going to look at harm reduction in the HIV epidemic, because that's really where harm reduction took hold legislatively here in the United States. We'll then turn to look at some of the Good Samaritan laws that provide criminal immunity for drug users who suffer overdoses. And we'll look at some specific state examples of how these laws have been drafted, and also in certain cases how they've been implemented, and also discuss a little bit of the problems that arise from how these laws are drafted and how they're ultimately implemented. And then finally, we'll turn to criminal immunity for sex workers, something that's recently been introduced in Alaska. So I thought I'd start with the definition of what harm reduction is. And harm reduction, the key thing that you need to understand about it is that it doesn't focus on a harmful activity so much as it focuses on trying to avoid the harms that arise from certain illegal activities. So whether that's drug use or whether that's sex work, you're not trying to stop sex work, you're not trying to stop drug use. You're trying to stop all of the harms that are associated with those activities. And that's kind of the key feature of the key reason why these laws were adopted in many states. So harm reduction was first considered during the HIV epidemic, and it was really discussed in the context of intravenous drug users. There'd been a whole lot of efforts to try and curb the spread of the disease within the United States. And one population that wasn't getting the benefit of all of these activities and where we weren't seeing a reduction in rates of transmission was in intravenous drug users. It was really a last resort, and you can kind of understand it when you look at the context of the war on drugs in the US and the prohibitionist attitudes that are really entrenched in the country. Getting to harm reduction and having it instilled as a part of the law was quite a difficult thing to do. And the way that it was adopted in the context of HIV was initially through needle exchanges and syringe exchanges. But this firstly faced a lot of political difficulty, but it also faced some legal difficulties in that a lot of states criminalized the distribution of needles and syringes because it was drug paraphernalia. And in certain states, you even needed a prescription to have possession of syringes and needles. So that was one of the biggest legal problems that these sorts of exchanges faced. Now, those exchanges faced those decades, and it was only really in the early 2000s that things turned around, and there was state and in some cases federal support for needle exchanges. Now the needle exchange programs are still going strong. They have a lot of state support, not as much federal support, but I did actually visit a a harm reduction center in the Lower East Side in Manhattan recently, and they were talking about how a lot of needle exchanges have started grouping together and sharing resources instead of running themselves independently, and they were funded by 2 state grants and 2 private donor grants. So you can see that they're still going quite strong. So, oh, sorry. So now we're going to turn to Good Samaritan laws as kind of the next step in how people, in respect of, because this is how criminal immunity has been applied to drug users more recently. Good Samaritan laws were not initially designed for drug users. They were essentially civil immunity statutes that prevented you from suing someone if they acted to essentially do a good deed. So the classic kind of Roman law example is your house is on fire and your house the fire. You can't then sue your neighbor for the broken window. A lot of states adopted these Good Samaritan laws for things like traffic accidents. So if you pull over at the scene of an accident and you try and help someone, that person can't sue you for any negligent harm that arises from your actions. They were then expanded to kind of deal with the opioid crisis. So sorry. So the opioid crisis has really been a big driver of the adoption of Good Samaritan laws in the context of criminal immunity for drug users. But before these Good Samaritan laws were expanded to drug users, they were initially coupled with harm reduction measures of expansion of naloxone access. Now, naloxone is basically a drug that reverses opioid overdoses, and it can be administered up until an hour after the overdose. So it's quite an effective way to prevent fatalities from overdoses. What a lot of states did, the first was Mexico, was to allow either third parties, that is like friends of drug users or family members, to get prescriptions for naloxone to keep it in their house, so that if someone they loved or cared about has the of naloxone was initially criminalized, to prescribers and so like I said, they were initially adopted to, then these Good Samaritan laws were adapted to provide criminal immunity against drug-related offenses for people who seek medical assistance. The key aspect of these is that you need to have sought medical assistance, either for yourself experiencing a drug overdose or for someone else who's experiencing a drug overdose. You don't get the immunity if you just happen to experience an overdose and you kind of left someone there. And the goal of these laws is really to encourage people to seek medical assistance. That's the fundamental goal behind it. So the harm that you're trying to prevent is you're trying to prevent fatalities from overdoses and other kinds of negative health consequences. The first of these laws was adopted in New Mexico in 2001, and now 36 states plus the District of Columbia have adopted similar laws. Now, although these laws all seek to provide criminal immunity as their general objective, and they're all trying to deal with reducing harm and reducing fatalities from overdoses, there's a very big variance in how states have chosen to do laws that cover all sorts of things from arrest, parole violations, while others require people to undertake treatment following the overdose. So the way in which these laws are framed really influences how people perceive them, whether or not people are going to be able to use them, and ultimately whether they're going to be able to achieve the harm that they're trying to protect against. So the general requirements for all criminal immunity statutes are that they provide immunity against conviction, at the very minimum, for some kind of drug-related offense. That can be possession of drugs, it can be possession of drug paraphernalia, it can be being in an area where drugs have been used, using drugs, depending on the way that the state has chosen to criminalize drug possession and chosen to frame drug-related offenses, that often informs how the state, what offenses the state chooses to provide immunity for and how they provide that immunity. The second requirement is generally that the person needs to have sought medical assistance. And as I said, because this is the key objective of the legislation, that's why this requirement is included. The next requirement is that the evidence that the person seeking medical assistance. So this sort of avoids the situation where the evidence was obtained independent of the person seeking medical assistance. And it also tends to avoid the situation where someone maybe fakes seeking medical assistance and then tries to get out of a conviction by using this cause as a way out of conviction. But as I said, some states provide additional requirements and they change the way these different requirements are framed. So that's what we're going to look at now. And we're going to look at a couple different states. The first state that I wanted to start with was New York. And the reason I wanted to start with New York is because their penal law really draws the very close relationship between HIV, harm reduction, and criminal immunity for drug users. Because in the statute itself, you can see the part is highlighted there, it provides immunity not just for drug-related offenses, but for possession of a state syringe exchange, pharmacy and medical provider expanded syringe access programs. So you can see there that not only does it provide immunity for drug possession, it also provides immunity for all of the paraphernalia associated with harm reduction measures. The next part of the statute outlines the requirements that need to be met in order for someone to receive immunity under the statute. An overdose. And the thing that's particularly notable about it is that it's not restricted to drug overdoses. It's drug or alcohol overdoses or other life-threatening medical emergencies. So even if your friend isn't, or your loved one, or you aren't experiencing a drug overdose, you may also be experiencing some other kind of medical life-threatening thing that you can then get immunity for if you seek medical assistance to deal with that. The next example that I'm going to look at is a slightly peculiar, it's a slightly more detailed statute. And essentially the reason I've included it is because it covers a wide variety of offenses. So this kind of shows you the scope of what can be covered under these statutes. So I'm just going to basically run through all the things that are outlined here. And the first is, what do you receive immunity for? And you can receive immunity for possession or control of regulated drugs, procuring, possessing, or consuming alcohol by someone who's under 21, so that's essentially consumption of alcohol by minors, or providing to and enabling that consumption, being at the scene of a drug overdose, or being within close proximity to any person at the scene of the drug overdose. So you can see it's really wide, it's really all-encompassing. So this isn't just about people who are using drugs, it's people who may be in the vicinity of someone who are using drugs and may be afraid to contact medical services because they don't want to get in trouble and they don't want to get their friends in trouble. So this is the kind of law that you want to have. You want to have it be broad and you want to have it encompass as many things as possible. The law, interestingly, also provides immunity for violations of protection orders and violations of pretrial release, parole, and probation. These are also quite important because a lot of people are on parole or they are on pretrial release or probation. And this can make a huge difference as to whether or not they contact medical services. Because often possession of drugs is violation of parole. So including this is also reaching a very big target group of people who are suffering these kinds of harms. And then you can see the requirements, they're not lengthy, they're just at the bottom there, which is just that you need to have requested the medical assistance in a timely fashion, you need to have requested it in good faith, and the evidence of the offense needs to have been obtained as a proximate result of seeking medical assistance, not even a direct result, proximate result is sufficient. Cast the net quite wide. To be convicted if the evidence is obtained independently. The reason that this piece of legislation doesn't include possession of drug paraphernalia is because possession of drug paraphernalia isn't criminalized in Vermont. And then the last thing to note is just that this piece of legislation doesn't just cover someone who calls for medical assistance, it covers the person who's suffering the overdose as well. So you've got to remember there's a couple different scenarios. The one is that you have a friend and both of you are using drugs and one of you has an overdose and the other one calls for medical assistance. The other situation is where you yourself are using drugs and you would contact medical services because you're experiencing an overdose. And the third is maybe that there's someone who's completely independent of the situation who comes across someone who's experiencing the overdose and then wants to contact medical services. So this situation really covers all of those potential people and provides protection to all of those people. The next piece of legislation that we're going to look at is North Carolina. And North Carolina is also an interesting example because it's kind of the opposite of what we've just looked at. It only provides immunity for a very, very small range of offenses. And you can see them, they're listed there. It's misdemeanor possession of a controlled substance, felony possession of less than 1 gram of cocaine or 1 gram of heroin. The reason it's limited is because they're trying to avoid the statute applying to drug dealers. So their assumption is if you're in possession of more than these amounts, you're probably a drug dealer. So that's why it's limited. But when you look at something that's that limited, you have to ask yourself whether or not people are going to want to use it. Are people going to feel comfortable and safe to rely on this immunity when they contact emergency services? However, beyond the fact that it covers a very small range of offenses, it does provide immunity from not only arrest and conviction, but it also provides immunity for violation of pretrial release conditions, probation, parole, and post-release, provided that all of the requirements are met. The requirements for this law are a little bit more detailed than the previous two that we've looked at. Why is that the person who sought medical assistance and who is seeking immunity under this law is only entitled to the immunity if they contacted the 911 service, law enforcement, or emergency services personnel. So it's a very small list of things that you can do in order to get immunity. You can't just have called for help generally. You need to have contacted one of this list of people. The second is that you acted in good faith with the reasonable belief that you were the first person to call for assistance. So if you think that someone else may have called for assistance, you won't get immunity under this law, even if you were the first person to call. So that's also a problem, is that you, it's essentially disincentivizing you from helping if you think someone else has already assisted. And that, again, the narrower you make it, the less likely it is people are going to use it, especially when there's a lot of requirements that someone may or may not meet. How do you establish a reasonable belief? It's not something that a normal person would easily ascertain and understand. The second is that the medical assistance must not have been sought for if during the execution of a lawful search. And this is essentially to avoid the situation I outlined before, where someone's lawfully being searched and all of a sudden they now need medical assistance for maybe an overdose, maybe something else. So this is really just sort of like it's almost like a substitute for the good faith requirement or an add-on to the good faith requirement, I think. And then the final thing is that the evidence needs to have been obtained. The next statute that we're going to look at is Minnesota, and you can see it's quite a detailed statute. So I have underlined and highlighted the relevant parts of it, but this one is one of the more problematic pieces of legislation, not the ones we've covered so far. This one is the problematic one. So the first is that the person needs to have acted in good faith for a person who is experiencing a drug-related overdose. So now that is restricting it to just drug-related overdoses, not other kinds of harm. So if someone does need medical assistance, but it's not for a drug-related overdose, they don't get immunity under this statute. The second is that they may not be charged or prosecuted. That's quite good because it prevents you from even the risk of being arrested, which is a good kind of protection. It means that you don't have to go through the whole trial process of being arrested, being booked, being charged in order to invoke the immunity. The second is the standard, it needs to have been obtained as a result of the person seeking medical assistance for another person. And but the key part that's problematic is the second requirement, which is that the person seeks medical assistance for another person who is in need of medical assistance for immediate health or safety concerns. So that's quite, it needs to be immediate. It can't be something that's sort of like possibly going to happen in the future. And then is the first person to seek the assistance. And the particularly problematic parts are provides a name and contact information, remains at the scene until the health services personnel arrive, and cooperates with the authorities. Now, all of these things, firstly, providing your name, providing your contact details, staying at the scene, all of those things are going to be disincentives for someone using this tool. No one who's at the scene of a drug overdose wants to give their name and wait for the authorities. They kind of want to call and run. So this is problematic. But the most problematic part of it is the part that I've highlighted in red, which is that the person needs to have cooperated with authorities. And what that means is say that they and that's why it's particularly problematic. So yeah, I mean, I've run through these requirements already, but just to kind of frame it in the way that we've seen the other states, just to say that the requirements that you need to be the first person to seek the immunity, provide the name and the contact information, remain on the scene and cooperate. And then also just to mention, the immunity also covers pretrial release, probation, furlough, supervised release, and parole. The final state that I'm going to look at is Ohio. And Ohio is probably the most problematic when it comes to implementation of this Good Samaritan law, as well as having a very problematic Good Samaritan law in and of itself. So as you can see, they start with a definition of what a qualified individual is. And in order to receive immunity under the statute, you need to be a qualified individual. And it automatically excludes people who are under community control or post-release control. So that means that if you are on probation or if you're under pretrial release or something like that, you are excluded from this kind of immunity immediately just by virtue of the fact that you're on probation. Acting in good faith. So those two requirements we've seen before. It's to seek or obtain medical assistance, protecting someone in person. So it's quite a wide range because it does say that it's including but not limited to a range of people. A minor possession offense. So it's not clear what that minor necessarily means. It would probably be a misdemeanor offense, not a felony offense. So that immediately restricts the pool of people who can receive this immunity. And it also does raise questions about what sort of minor drug offenses can lead to overdoses, because often overdoses are a result of using opioids like heroin or using stimulants like cocaine. Generally minor drugs like, for example, weed, don't trigger overdoses. So then you have to raise that immediately. The second is that the evidence is obtained as a result of the person seeking medical assistance. That's quite standard. It then requires that the person who sought or obtained the medical assistance, that's either the person who was seeking medical assistance or the person who was experiencing the overdose, needs to have sought and obtained a screening and been referred to a drug treatment program. They then need to, if any prosecutors ask, produce documentation and allow the prosecutor to verify that they've been enrolled in such a program. Now, it doesn't specify that this person does it at state expense. It doesn't indicate that the cost of this is going to be somehow taken care of by the state. So not only is it a very burdensome requirement, but it also places a financial burden on the person who's seeking the assistance. So to me, this really looks like a law that isn't trying to achieve harm reduction. It's really trying to reduce the number of people who use drugs. And it's creating a lot of burdens on people who use drugs in that process. The issue that arose with Ohio was that law enforcement officials decided to try and circumvent this very limited, very small Good Samaritan law by instead charging people who suffered overdoses with the crime of inducing public panic. As of this report, which is March this year, they have arrested 12 people and charged them and convicted them with this misdemeanor. And it carries a term of imprisonment. So when you look at how law enforcement implements the statute, you can see that they don't buy into it. They're simply going to circumvent it and try and sort of use criminal sanctions in other ways. So Ohio is a very good example of problematic Good Samaritan law coupled with problematic implementation.
That's the crime again was inducing public panic.
Yes. You can see a quote. This is a quote from the Human Rights Watch report, which said that within the last two months, the city's law enforcement has charged at least 12 people who have overdosed with inducing public panic. So this is the end of the Good Samaritan laws with regard to drug users portion of the discussion. I'm now going to turn to criminal immunity for sex workers, but before I move on, I just want to check if all of that was clear, if you had any questions, if it all made sense.
How aware is this population of these laws? Like, do we have any
in
idea?
Ohio
Or just in general, like of immunity laws, like.
I haven't seen a lot of data. A lot of the studies have been done on police, the studies I've seen have been done on police attitudes. It's kind of a mixed bag. In New York, they're kind of open to it, but I don't know if Sean can speak to.
I don't think we've really looked into like the general awareness. I'm sure there's not that much awareness of the laws. But I mean, I think the kind of the underlying point that I think Safura is kind of pointing out is that if the purpose of these laws are overall to kind of do harm reduction, essentially, to prevent overdose or other types of medical emergencies. If you're adding in additional barriers, as many of these states are, you're definitely conflicting with the overall goal. And so we would like to see, I mean, I think we're going to talk a little bit more in the sexual context, like kind of a model for like what the most effective type of law is. And regardless of whether people themselves know about it, we want to be making sure that we're promoting harm reduction and like preventing overdoses as opposed to like adding additional barriers. And I think one thing that we also noted in terms of states was, I think there's only one state that specifically allowed for immunity for someone who has an outstanding warrant, for instance, right?
Right, that was Oregon, yeah. So Oregon does have this, if you have an outstanding warrant and you seek medical assistance, then you would be brought in on that warrant.
Yeah, no worries. But like those are the types of things I think when you think about it in the real world. Like, so if you have run afoul of the law at some point in time. So I mean, I think many of the states that we've covered so far, I think did include. So if you're on like if you're on probation or you're on parole, say you're in a vicinity of someone using drugs, that probably is in violation of parole. You yourself may be using drugs, and so you might be less likely to want to call for your friend or for yourself if you are using drugs, experience an overdose, or experience some other type of medical complication. It's really important to have like those types of provisions. We don't see that in all states, but I think more and more have been moving in that direction. We need to make sure that those type of requirements are there. Like if you are someone who has an outstanding warrant out, and again, warrants can be for any number of things, or whether they be minor traffic violations or other things like that, you might be less likely if you knew about the law. So again, we don't think we have enough data to say the general awareness, but I think that's an important issue for us to think about. But you might be less likely to take advantage of it, and therefore you would, you could possibly experience either fatal overdose or any other type of health complications. When really these laws are supposed to be encouraging you to seek medical attention.
Just from an anecdotal level, like the harm reduction things I did ask them about general awareness of the Good Samaritan law in New York. And they said that when they train people to administer naloxone, which is one of the programs that they run when people come in, they they give them a little card that sort of outlines how the Good Samaritan law works and what the requirements are. But they said despite that, people are very reluctant. But this is again just a small harm reduction center in Manhattan, like it's not representative of the general population, but that was sort of the anecdotal information that they gave. So I thought it was interesting that they distributed those cards. I think that's something that I would definitely increase awareness to some degree.
Yeah, in terms of doing awareness, ideally, the simplest statute probably is the best in terms of communicating. Like if you call the police or if you call, medical personnel, you will not be convicted of a crime. Versus if, you start to have these type of awareness campaigns, but then people actually see in practice, they often don't apply to me or to my friends. That's going to undermine the overall kind of public health rationale behind it. So.
Sorry, there's another question?
Yeah, I'm just interested in this inducing panic statute and if there's any understanding of why they are invoking this. It seems sort of like the legislature and then the police have two very different, goals. Like they have this, okay, it's not a great law, but they do have a law, and then they're sort of going invoking unusual approach.
Yeah, I mean, I haven't been an in-depth analysis of this. I mean, as you can see, the report came out last month, and it's just a small group. I mean, it's small, and it's 12 people. But to me, this really spoke to an effort to circumvent the intention of the legislature. Instead, you can't charge people with a drug offense, so we're instead going to charge them with public panic. This isn't a meaningful response to the opioid crisis. This is really just sort of like a draconian idea of like, well, maybe if we charge them with a misdemeanor offense and we fine them for getting an overdose, then they'll stop overdosing, which, as we know, is not an effective public health response. Yeah, sorry, Tanya?
Sorry for being late. I don't know if you can tell it at the beginning, but I would like to know which is the difference between these immunity programs and other kind of programs like drug courts, for example, are like alternatives for incarceration. But I don't know technically which are the difference and if both can coexist.
I think definitely both can coexist. It really depends on the scope of. I think it firstly depends on how drug courts operating, because as you know, they operate differently state to state, and then secondly, it really depends on the scope of the Good Samaritan law. I don't think they're designed to work against each other. I think that they're probably designed to actually work together to some degree. Good Samaritan laws tend to target people who are specifically seeking medical assistance. So this doesn't protect you if you just happen to be walking down the street in possession of controlled substances. It's really designed to target overdoses and reduce the fatalities that have arisen from overdoses, specifically in the context of the opioid epidemic. So in that sense, I think they fulfill very different purposes. But also, I think drug courts are to some degree also a harm reduction measure. I think they're all about kind of getting people diverted away from the criminal justice system and encouraging treatment. They're more of a public health response than a harm reduction response, I think. But they can coexist. Yeah, I mean, it's something that we've looked at, and we haven't compared this and how it coexists with drug courts, but it is an interesting.
Yeah, I mean, the focus again is on kind of someone who is preventing like a drug overdose or a medical emergency. So again, all the contexts where that does not apply, whether it's drug possession or health issues that are related to drug usage or abuse, that's where you would need kind of alternative kind of criminal alternatives, essentially, so diversion programs, things like that. So this applies to a very kind of narrow case, but where they do apply, we want to make sure that the laws are robust enough to kind of protect people so they're not disincentivized.
Oscar said he'd ask a question.
Oh.
All right. So Oscar's question is there any law or regulation from the US or abroad that can be considered a best practice in this space?
I think from our survey, I think we thought the New York law was pretty good.
Well, and the Vermont law is also very broad as well. We're going to continue. So we've talked so far in the kind of drug use context, but we're going to talk a little bit about criminal immunity related to sex workers. And a model law has been developed by the Sex Workers Outreach Project, which is relevant to sex work and sex work related crimes, but also is very inclusive of other crimes that are used regularly against sex workers, including crime for drug offenses, and things like that. And so that's definitely a model, and so we can kind of dissect some of those pieces and kind of get your thoughts on that side.
Yeah, so I mean, I have included a brief discussion about that because that model that was developed isn't exclusively applicable to sex workers. It was actually developed as a model Good Samaritan law that includes immunity for sex workers in certain contexts. So it's a very different law to the law that we're going to be looking at in the context of Alaska, which is purely immunity for sex workers. So that model law that the Sex Workers Outreach Project is probably the best.
Yeah, so we'll go over that.
Yeah, but we'll get to that eventually. So, sorry, are there any other questions about drug immunity?
Is naloxone difficult to use? What is it, like a shot?
It's kind of like, as far as I understand, it's kind of like an EpiPen. But they do have training, so they not only train police officers on how to administer it, but generally when a whole lot of states have instituted programs where if you get a prescription for naloxone, you'll also be trained on how to administer it. And a lot of harm reduction centers that dispense it offer training, so they won't dispense it without training the person on how to use it. That's it. I don't think it's that difficult to use, which is why the expanded naloxone access was kind of the first effort of harm reduction in the context of the opioid epidemic. I think it really changed the game in terms of what kind of harm reduction response we have to the epidemic. Any other questions? All right. So now we're going to look at Alaska, and before I want to dig into what the sex worker immunity law looks like, I want to just give a little bit of context to the Senate Bill 91, which is the criminal law reform statute that introduced this immunity. And it's worth looking into because it's not just a sex workers immunity law. It's actually a major criminal reform. And it really was prompted by Alaska's kind of insanely high rates of incarceration. And so a lot of the measures that were included in there are really to try and get people out of the system. They're trying to encourage people to contact the police, try and encourage, more effective policing, but really trying to avoid people going to jail for things like parole violations that are minor and small offenses and things like that. So really kind of adjusting the punitive element of criminal justice to more of a restorative justice kind of approach. So it is a very interesting law in and of itself. It was passed last year in July, and subsequent to its passage, there's been a committee that's met and sort of made some recommendations following how it's been implemented. None of the recommendations are about the sex worker immunity law, so we don't really know how it's been implemented and what it looks like really, but we do know how the rest of the statute is being perceived, and it's kind of a mixed bag, and it's really, so I just thought I'd go through some of the things that the statute did, not just with regard to drug-related offenses, but also to offenses more broadly. So the first major thing that it did was, and I thought this was particularly interesting, was it reclassified all drug possession offenses to misdemeanors with the exception of date rape drugs. So the only drug possession charges that are felonies is possession of date rape drugs, which I thought was quite interesting. The second is that it does away with, it reclassifies certain property crimes. So the first is that it changes the felony property crime value from $750 to $1,000. So it's keeping more property crimes as misdemeanors rather than felony offenses. And it does away with imprisonment as a sanction for any property crimes under $250. And the reason I mention that is because that's probably the aspect of the law that's received the most criticism. It's the part that people are very upset with. When it comes to implementation, they feel that the crime rates around theft and shoplifting have gone way up following the implementation of this law. The other thing that I thought was worth noting was the couple of changes it makes to the way parole operates. So the first is it introduces something called administrative parole, which is parole that is you're automatically considered for it. You don't need to apply for parole. And the second is that it introduces geriatric parole, which is if you're over 60 and you've served more than 10 years of your sentence, you're automatically eligible for parole. I think that's the way it works. And then it also limits the use of incarceration to sanction parole violations. So it's something like for the first 3 parole violations, you shouldn't use incarceration as the sanction. Of course, there are major parole violations, then incarceration is acceptable, but for the most part, they don't see parole violations as something that should be sanctioned incarceration. And then finally, there's a couple of provisions that sort of expand victims' rights. So it is quite a radical law in and of itself. And the other most notable thing, and the thing that we're here to discuss today, is the fact that it is the first state to adopt criminal immunity for sex workers. And that's what I'm going to look at next. So this is the text of the bill. And what it essentially provides is that if a person witnessed or was the victim of, and then it gives a list of certain offenses, the evidence that would support their conviction of the offense of prostitution was obtained as a result of them going to law enforcement and reporting this crime, they will be immune from, being prosecuted as a prostitute. Of course, it contains the ever problematic word cooperated. So the requirements, if I can just go back and reiterate them, are that the person needs to have witnessed or been a victim to a certain offense. They need to have gone and reported this offense to law enforcement in good faith. The evidence that would have sustained their conviction as a prostitute needs to have been obtained as a result of them going to report the offense, and the person needs to have cooperated with law enforcement. So that's the problematic part of it. The probably the most notable part of it is the list of crimes that qualify for immunity, and it's really quite serious crimes, things like sex trafficking, murder, assault, sexual assault, things that sex workers are often exposed to and often don't get protection for. So it's really, the governor wrote a letter and op-ed about this, and he talked about opening pathways between sex workers and law. It's really about the harm that it's aiming to reduce is A, the crimes committed against sex workers, but B, also crime generally. It's trying to encourage sex workers who witness these sorts of offenses to report them to law personnel. Of course, we don't know how it's being implemented. It's quite a new law. We don't know whether or not it's worked. And the vague phrasing of what cooperated means that they don't want to use it because they don't know what that cooperation is going to entail. Are they going to need to act as a witness? Are they going to need to give information about their trade, about their list of clients? What cooperation means is quite sort of unclear. So that's probably the problematic part of the statute, and then the immunity is limited, as I said, to the crime of prostitution. So trying to circumvent this law by charging them with like misdemeanor traffic violations and things like loitering, crimes that sometimes prostitutes are charged or arrested for, but that are not necessarily prostitution per se. And then it only provides immunity against conviction. So what this means is that sex workers can still be arrested, they can still be charged, they can still go through the whole trial process, they just can't be convicted. So it almost functions as a defense more than immunity per se. So all of the disruption that arises from arrest and from going through the criminal justice process is still there with this law. So it's definitely not a perfect law. It's very far from that. But it is the first law that we've seen. So I think that's quite meaningful. I have to say about the Alaska law. The next thing I just wanted to talk to before I take any questions was just the model law that we discussed earlier. So this was a law that was developed by the Sex Workers Outreach Project. It's part of a toolkit that they developed. And the toolkit is really about getting states to adopt expanded Good Samaritan laws that cover immunity for drug users and sex workers. So it's really about marrying the two as one harm reduction measure. What they have included in their list of requirements, it looks quite detailed, but it's only detailed. It only looks that detailed because of the scope of what it covers. So you'll see a lot of the same things that we've seen, which is that you need to seek medical assistance for someone who's experiencing a medical emergency. Now, they didn't restrict it to overdoses. They said it includes an overdose, but it includes other kinds of medical emergencies as well. They kept the requirement of good faith, so that again stops people from like faking a medical emergency when you're doing a search and things like that. And then this is a list of all the kinds of immunity you receive. So you can't be arrested, you can't be charged, you can't be prosecuted, you can't be convicted, you can't have your property subject to civil forfeiture, so that includes your drugs. So if you're arrested and there's all your drugs can't be forfeited. Interestingly, they've also included immigration. So you can't be subject to any immigration or child protection services. Whether or not the latter is a good thing is debatable, but these are all, when you're seeking to reduce harm, the more inclusive it is, probably the better it is. And then the offenses that it provides immunity for are drug possession, paraphernalia offenses, underage drinking offenses. So we've seen this in some of the other statutes. And then broader drug charges, including low-level sales and offenses specific to sex workers. So that would be things like prostitution, but also it could be other offenses that sex workers sometimes get charged with, but are not necessarily directly prostitution. They haven't specified it; they've sort of left it up to the state, depending on how they've criminalized sex work. The legislature can sort of develop that a bit more, and then violation of protection order, violation of parole, pretrial release that we've seen in other states that have expansive laws. And then the final thing is that the evidence that would sustain the conviction of any of those offenses is obtained as a result of seeking medical assistance. So I'll just pause here because this is sort of the end of the formal legal part. There's a little bit more, but do you have any questions about the moral law or about Alaska's law? Does YouTube have any questions?
No.
Okay. All right. So for the last part of the presentation, I'm going to actually turn over to Sean because he's going to talk a little bit about a project we've been working on to do with sex workers and criminalization. And then, did you want to discuss that?
I'll let you discuss that, but I'll talk about the project that we're doing here. So we received funding from the John H. Foundation for a project on improving laws and policies to protect sex workers and improve their access to prevention and treatment. That's a project that we received funding for at the beginning of the year, and we're working in collaboration. This is an LGBT and HIV focused health center here in Washington, D.C., as well as HIPS, which is the sex worker advocacy organization, services for people who use and inject drugs. So it's a three-partner organization. Really, the focus of it is to explore how sex workers in Washington, D.C. access healthcare services, how they interact with law enforcement, and also how interactions with law enforcement and laws that are meant to disrupt commercial sex trade in any way, how they impact the ability of sex workers to care and to access, as well as social services more broadly. And so that project is going to be ongoing over the next year. We're going to be doing a series of focus groups with sex workers here in DC to kind of find out about the issues that they're facing, issues around, again, interactions with police officers, whether it be and violence, experiences with arrest, things like that. Where they're accessing healthcare and what programs are currently being offered through community-based organizations, as well as DC or other programs that particularly focus on services for sex workers. And what are the impact of particular criminal laws? So what laws are actually being used to charge against sex workers? We have seen some progress here in DC in terms of how often sex workers are actually charged with and prosecuted for prostitution. So there's been a dramatic decrease. I think for a number, probably about a decade or so, we had probably around 800 or more, kind of charges or and so fewer prosecutions, but around 800 charges. Now I think it's just over 400. Those are not the main ways in which sex workers are prosecuted through prostitution laws, but that's not to say that sex workers are not still going through the criminal justice system. And so the types of laws that are often invoked are things like failure to obey a police officer, resisting arrest, assault of a police officer, violations, as well as drug crimes and other, again, can be used to target and still lead to increased involvement in the criminal justice system. But we want to kind of get a better sense of really what's going on here. Some of the ideas that sex workers have in terms of what are some of the solutions? I mean, some of the solutions are going to be changes to criminal laws, but there also might be other non-criminal laws and policies that change, as well as develop programs and support services for sex workers. So we'll hear from them, doing one-on-one interviews with counsel, law enforcement, with legal and public health officials, as well as providers and other service providers working with sex workers. And so all of that together, along with some of the research, the research we've already been doing in terms of options for criminal immunity, Good Samaritan laws, different types of diversion programs and models that have been enacted in other states. We'll start to kind of develop what can be the step forward, the way forward in terms of moving towards criminalization, possible decriminalization of sex work, and whether so we'll put all of that together into a report and continue to do education, as well as our partners working on kind of broader advocacy efforts to kind of make sure we're supporting and protecting sex workers here in DC, and maybe there may even be additional opportunities to kind of expand this work beyond DC in the future. So that's a project that we're very excited about. I'm going to be updating that website regularly. If you guys have any questions about that, please let me know. And then I'm going to turn it back over to Safura.
Yeah, so I'll just end up with discussing LEAP, which is basically law enforcement assisted diversion. It's kind of like drug courts, but it removes the criminal justice system from the equation entirely. So, save for law enforcement. So what it's been implemented in Seattle. A couple other places have also adopted it. Some states, I think New Hampshire's adopted it or something. And some places have variations of this. And basically, it tries to view drug offenders and prostitutes as victims rather than offenders, and directs them towards community-based services rather than turning them towards the court system. So it tries to get them like treatment, or maybe it'll be skills development, things that will essentially stop them from committing illegal activity, but not in a criminal sanction kind of way, but more in sort of like a.
And it's important to just note that this is there are different types of diversion programs. I guess probably the most common in the US is a pretrial diversion. So after you kind of prosecuted, you could either have that sentence implemented or you can be diverted. And so as long as you meet conditions of the diversion program, whether it be accessing services, not doing the behavior that's criminalized, you will not actually have to spend time in jail. This is a pre-booking diversion program, so you won't even be charged. You won't be, ideally you need to be taken in, but sometimes I think, in terms of the way this is implemented, you might have to be taken in just, overnight before you can actually get, connected to some type of a service provider, a social worker that you meet with. I think the way they've structured it in Seattle, a minimal burden. I think so you just need to meet with someone, and be connected to services, whether you're going and meeting with them regularly or, you have to do it for a certain period of time. You just have to meet with them once in I think 30 days. And ideally they like to try to get you, if you've been, if you've interacted, you've come into contact with police officers during the day, they'll just kind of bring you in, you can have your appointment right away. Hopefully be connected to services, that can, help you to deal with, drug use or any other kind of issues that you're dealing with. But it really, again, it's kind of a public health approach and really getting law enforcement to be working together with and making sure people have access to social and clinical services. So it's a type of model that we're seeing some expansion of, as Safura mentioned, and it is something that we're going to be looking at in terms of ways forward here in the district to kind of, or at least implement something similar to kind of a pre-booking diversion program, as well as things like criminal meetings.
Any questions? We have some time left, so.
Can I ask on the last thing? So my reaction to this is this might be almost an intervention for law enforcement. I feel like some ways just culturally they're just so resistant to anything to do. Do you have any experience with how this is working? Or has it been embraced by law enforcement in Seattle?
It seems like it's been embraced there. It's not being implemented, I don't think, citywide, so I think it's in certain precincts where it's being implemented, but where it is, I think the police officers are taking it up and they're using it, and they're working together and starting to see their role as being different from just someone calls and I respond to someone using or drugs or causing some type of a commotion in the community, rather than the first response be, oh, I'm going to arrest you. We're going to be thinking about this in kind of from a more kind of health and social perspective. So kind of taking on the hat of like being a social worker, which I think there are a lot of roles that police officers play, but that's definitely one that they should be playing more of. And I think in many cases they don't receive the training to do that. And so where they have implemented and they've done the training, it's been very successful. But again, this is one of those things where if you're not in a precinct in Seattle where they've done that training, you could still be arrested. And so like enforcement at this point is like, it really depends on, whether, where they've done the actual training, where they're implementing lead, and whether, the police officers are actually, actually following through with that training and actually implementing it. So yeah, implementation is, I think, at the key to all of this. So we have the law, we want to make sure we have, criminal immunity, lead, those types of policies actually, approved, funded, but like how they actually look on the ground and how individual police officers take them up is kind of the next step after you get it. And so that's why we need to have continual monitoring of these types of offenses, also or these types of programs and legislation, and to make sure it's actually culture, actually changing things on the ground. So.
Yeah, and I think that applies more broadly to to all of the Good Samaritan law, things like that. If the law is poor, that's a problem. But even if the law is fantastic, it's not implemented, it's not embraced, then you have a situation like Ohio arising.
Absolutely.
Right.
Did you guys run into the intersection with anti-trafficking laws and how they're used against sex workers?
See, I'm trying to remember because in the context of the SB 91 Alaska bill, there was a whole lot of detailed carve-outs around sex trafficking and this ability to get immunity for reporting sex trafficking, but there was also this reclassification of sex trafficking offenses that was found to be incredibly problematic.
Yeah, I think I don't remember all the details, but I think two of the big issues in Alaska, and I'm sure they're true in other states, is can someone be sex traffic themselves? And like we're having laws like that where that happens regularly, changing the law so now in Alaska that cannot happen. Nor can you.
A group of, if you have a certain number of sex workers together, provided that it's like a certain number, that can be classified as sex trafficking. They can be like sex trafficking themselves. That was one of the changes that they adopted.
Yes.
And that was one of the recommendations from the committee is that changed. Because of the way it was worded, it was sort of this weird thing where if you had a certain number gathered together, all of a sudden it was a sex trafficking ring. And liable to prosecution. I don't know why they adopted that.
Is that in the new bill? Like,
it was in the committee recommendations. That was just like something random that we
That's
gave.
sort of exactly my
Yeah.
question. It's like,
So
it's a real.
they did change that. That's a challenge that is in most states and was in Alaska.
Yeah.
This law clarifies at least that particular exception, but there still is a lot of conflation between sex work and sex trafficking, and continue to be thinking about on the level, obviously. Yes.
Yeah, I mean, it's not clear with all the recommendations that the committee made about the Alaska law. It's not clear whether or not any of those are going to be implemented and things like that. Obviously, there's varying degrees of political pressure around different recommendations. So that's also something that we need to look at. But like I said, if there were no recommendations about the immunity, yeah. Any other questions before we wrap up? Any YouTube questions?
Yeah, that's it.
All right.
All right. Thank you guys all. Thank you for that.